Hello everybody, this is Aishley Verma and joined with LEXIS and Company, and today in this video I will be dealing with a case named Proddatur digi Cable Service versus City Cable Network Limited. The citation of the case is OMPT COM 109 by 2019 and AI 17896 by 2019. It was filed in the High Court of Delhi, and the bench consists of Honorable Justice Jyoti Singh. Date of the judgment is 20 January 2020. Head notes of the case includes Section 7, Section 12, Clause 5, Section 13, Section 14, 15 and 21 of the Arbitration and Conciliation Act 1996. Facts of the case includes the following. The present petition has been filed under Section 14 and 15 of the Arbitration and Conciliation Act 1996, seeking a declaration that the mandate of the arbitrator appointed by the respondent be terminated and an arbitrator be appointed by this court in accordance with the provisions of the Act. The present petition arises out of the distribution agreement entered between the parties on 3rd August 2015. Clause 13 of the agreement provides for the resolution of the dispute between the parties by way of arbitration. Certain disputes arose between the petitioner and the respondent as to the amounts due to the petitioner during the subsistence of the distribution agreement. It is the petitioner's case that all his efforts to amicably recover the amount from the respondent failed, and upon which the petitioner invoked the arbitration clause, which can be seen in the notice dated on 29th October 2018. The petitioner nominated an advocate as his arbitrator. Further, on 9th January 2019, the petitioner requested the arbitrator as notified in the letter to enter upon reference, and on 19th January 2019, the first procedural hearing was conducted. The petitioner avers that on 10th January 2019, the arbitrator addressed a letter to the counsel of the parties seeking consent of the petitioner and to her appointment along with her disclosure under Section 12 of the Act, which is Arbitration and Conciliation Act. The petitioner responded by a letter dated on 4th January 2019, declining consent to her appointment. Further, the petitioner avers that through his counsel, it sends an email dated on 28th January 2019 to the arbitrator pointing out that the objection regarding procedure and jurisdiction would be raised in due course by the petitioner as per the provisions of the Act. Further, on 26th November 2019, the Supreme Court delivered a judgment in the case of Perkins Eastman Architect DPC and others versus HSCC India Limited in 2019. The citation of that case is SCC online SC 1517, in view of which the unilateral appointment of the arbitrator by the respondent is vitiated under Section 12 Clause 5 of the Act. Further, the petitioner avers that in view of the said judgment, the petitioner conveyed to the nominated arbitrator not to proceed with the arbitration as her mandate stands terminated de jure. The arbitrator, by an email dated on 7th December 2019, communicated that she would continue with the proceeding unless there was a judicial order terminating her mandate. Hence, the petitioner has filed the present petition. So these were the facts. If we talk about the issues with the case, so there were two issues. The first issue is whether unilateral appointment of an arbitrator by a party to the arbitration agreement is permissible, and the second issue is whether there is a distinction between managing director and company when the power of the appointment of an arbitrator is conferred. So, regarding these two issues, the court passed its judgment, and the judgment are as follows. In the view of the court, none of the contentions raised by the respondent can be sustained. As a corollary to that, the ineligibility of the company would translate and percolate to the arbitrator appointed by the company, and thus the arbitrator presently conducting the arbitration proceeding is declared to be ineligible to act as an arbitrator. Further, since the present arbitrator has become de jure unable to perform her action as an arbitrator, I means the court thereby terminate the mandate of the present arbitrator and substitute by another arbitrator. Mr. Justice Mukul Mudgal, former judge of this court, means the Delhi High Court, is appointed as the sole arbitrator to adjudicate the dispute between the parties. Further, the learned arbitrator shall give disclosure under Section 12 of the Act, that is the Arbitration and Conciliation Act, before entering upon reference. Fee of the arbitrator shall be fixed as per the fourth schedule of the Act. And lastly, the petition is allowed in the aforesaid terms. All pending applications are accordingly disposed of. So this was the judgment given by the Delhi High Court. Hope you like it. Thank you so much.